So we're going to go on with our program. So first to speak will be Los Angeles County Superior Court Judge Tom Long. He's a longtime member of the Palos Verdes Democrats, has traditionally spoken to our club in August, where he provides commentary on the cases reviewed in UC Irvine's annual Supreme Court Term in Review program. Judge Long was appointed by Governor Brown in December 2015 and has been on the bench since 2016. He was a civil litigation and trial lawyer for more than 33 years. Judge Long dedicated himself to public service as well, serving twice as mayor of Rancho Palos Verdes, 2007, 2011, during his 8 years on the city council from 2003 to 2011. He also led efforts to adopt a storm drain user fee, which funded essential infrastructure repairs throughout the city. And he also supported the founding of the 2 square mile Palos Verdes Nature Preserve. I did look at his LinkedIn bio, and I thought this was a very good quote. One of Rancho Palos Verdes' prominent real estate developers, Donald J. Trump, described Judge Long as both, quote, a great man and, quote, insignificant. Please welcome Judge Long.
Thank you very much, Anne. I appreciate that. And yes, I would say it's hard to thread the needle and be both insignificant and great at the same time. I think I'm doing a better job of the former than the latter, but be that as it may. My background is primarily as a civil attorney, and then during the 6 years or so I've been on the bench, all but 9 months have been in the civil arena as well. But I wanted to accept Anne's invitation to make some comments about the criminal justice system, because the 9 months I spent mostly dealing with arraignments and misdemeanors gave me some viewpoints that caused me some concern, not the least of which was the concern about the cash bail system and the impact it has. And my hope had been that the cash bail system was going to be eliminated. Sadly, it wasn't. And I'm sure the result continues to be, as it was before the pandemic, and I'm sure is still now, the majority of people in California's county jails, distinguished from the prisons, the county jails, are people who have never been convicted of anything. And while many of them may only be there a few days until they make bail, many of them now have to wait for longer periods of time until they can be tried. And so it allows a lot of leverage on them in terms of the plea bargaining situation as well. And the cash bail system, what it has the impact of doing is requiring someone to, even for a nonviolent crime, to escape the impact of the jail system, to post a bail. And the 10% that you have to pay to the bail bondsman may seem like not very much money and may seem like something everyone should be able to satisfy. But I was intrigued to find out that in California, the vast majority of people cannot raise $2,000 if they have to for an emergency. And there is a sizable minority that can't raise $400 either. This limits the ability of people to use cash bail as a mechanism for their release pending trial on the charges, and really sort of changes the balance of power in the criminal system. And that's one thing that would trouble, I think, almost anyone from a civil background is, well, what is the balance of power in the criminal justice system? If I, in a civil situation, a civil lawsuit, want to get a preliminary injunction against you, or a writ of attachment to take your money, or a preliminary injunction that tells you what you can or cannot do in your business, I have a high burden of proof. I have to have admissible evidence that shows by a preponderance of the evidence that I have a probability of success on the merits. And then even if I succeed in getting that preliminary pre-judgment relief in a civil case, I have to post a bond in the event I don't prevail in the case to cover the costs and the impact if I lose. The comparable thing, pre-judgment jailing of people, pre-judgment incarceration, which is what most people in our county jails are participating in, the standard is much different. The district attorney need not come forward with any admissible evidence at all. The allegations in the complaint are accepted as true. the defendant is not even allowed really to counter those allegations. And my experience when I was in an arraignment court and when I was in a misdemeanor court were that the bail hearings were really pro forma. There were days when I was asked to do well over 100 of them in one day, and there wasn't time to give the sort of consideration that should have been given, and there wasn't the funding to look into alternatives to cash bail. And even if people could afford to post the cash bail, in many cases, I noticed this when I went on to serve in an unlawful detainer assignment after my criminal assignments, is that many of the people who had to post money for bail then couldn't pay their rent and were subject to eviction. So the standard was something that startled me, that our legal system is structured in a way that we protect your money and your business a lot more than we protect your personal freedom, that there is little or nothing standing between you and the mere allegations of a district attorney incarcerating you. And this is something that now is being looked at not merely on the state level, but also at the federal level, where Harris County, Texas entered into a consent decree to try to change things and make the balance of power more even. In California, in state court, the balance of power is even more weighted in favor of the prosecution because the district attorneys have the power and aggressively use that power, at least when I was in a criminal assignment, have the power to remove a judge from any case at any time they want under what's called a peremptory challenge. They can only use one peremptory challenge per case, but they can do what's called blanket papering a judge if they're dissatisfied with the way the judge handles things. And it happened to me, although it wasn't blanket papering because I wasn't papered on every case, just enough to leave me with a docket that wasn't sufficient to carry my weight compared to others in the courtroom. And this was deployed, at least during the time I was in a criminal assignment, it was deployed as a mechanism of discouraging me, trying to discourage me from following case law called In re Humphrey, which ultimately was a Court of Appeal decision sustained by the California Supreme Court that required consideration of the defendant's ability to pay before imposing cash bail, instead of just imposing things rote according to a bail schedule. One of the things you notice if you look at our misdemeanor system is a large portion of the misdemeanor system is dependent upon, and I can't comment on the felony system because I really wasn't there except at the arraignment process, but a large portion of the misdemeanor prosecution is premised on the notion of criminalizing drug addiction, criminalizing homelessness, and using the leverage that the district attorney's office has in order to essentially encourage plea bargains that may or may not be in the best interests of the defendants involved. Now, I had different experiences, and different attorneys are supervised in different ways from courtroom to courtroom. I had one experience with a district attorney who was very open to diversion programs, which ended up being in the benefit of the defendants. I had exposure to another district attorney who wasn't as open for the very same crimes and insisted that everyone had to be convicted. So there used to be, and much of this may have changed, and I'm hoping to hear about a lot of that change, but there used to be, before Gascon became district attorney, from what I observed, a lot of power on the part of district attorneys in the courtroom, a lot of it unrestrained, a lot of it unsupervised, and a lot of it designed not really with the best interests of justice overall in mind, and designed with a system that's very unbalanced and provides only vestigial reminders of what used to be the protections for the defendants that we expect the system to have. So that's just my commentary based on my experience, which compared to the other two on the panel is, I'm sure, quite a bit more limited. So I look forward to hearing their thoughts as well.
Okay. Did you want to say anything also about the infrastructure?
Oh, well, here's something, no matter what our perspectives on the criminal justice system may be, I'm sure, all share the same view. I've been struggling now. I am the lone civil judge in Compton, and the Compton courthouse is actually in better shape than some other courthouses. Nonetheless, it's frequent that I do not have both working elevators and working public restrooms on the floor on the same day. And I do not have windows that provide an adequate shield from rain. We have a number of courtrooms throughout Los Angeles County that are in desperate need of repair. And I'm sure both the district attorneys and the public defenders and the civil attorneys who work in the courtrooms can talk about how desperate the need is. I had a jury trial that lasted a month last year from the middle of November to the middle of December, where every day I began the day with, ladies and gentlemen, I'd like to start with your elevator and restroom report and tell you what you can expect in terms of what's available to you. And I shouldn't have to do that. And I think that if we're not going to even say that we care about the courts, the district attorneys, the judges, the litigants, the public defenders, and so on, if we don't care about them, we should at least care. In fact, we should care even more about the jurors having to come in to these facilities that are really woefully inadequate, substandard in a way that is reminiscent of Charles Dickens' descriptions of the Court of Chancery and Bleak House. So our courtrooms are Bleak House, let's put it that way. Some of them are, not the new Long Beach one, not some of the others, but many of our courtrooms and many of the facilities provided for the attorneys and litigants and jurors are Bleak House, straight out of Dickens.
Okay. Just one last, we're going to do Q&A. I should have said this at the beginning. Q&A will be after all three speakers speak, and we'll have them on a panel. I do have one, but I am going to allow myself to follow up something here with Judge Long. So under $0 bail, courts and prosecutors already can and should and do hold defendants accused of murder, rape, and other dangerous felonies, including like the smash and grab robberies, that they can already say that there's bail. I mean, it doesn't, the zero bail doesn't say, $0 bail doesn't say that they can and should do bail.
Well, if there's a flight risk, if there's a danger posed to society, there's an ability to hold people. And in fact, a number of the opponents of cash bail were not just the political conservatives from a law and order bent, but were political left-wingers from the bent that they were concerned that a non-cash bail system, and very few other countries in the world, I think the Philippines and a small handful of others have cash bail. The concern was that it might result in more people being held, and it might. I mean, there might be some situations where you might have people who could easily, certainly, for example, I had a couple of cases of drug dealers when I was handling an arraignment court. They didn't object to the scheduled bail because they knew they could raise it. And I had to ask the district attorney in those cases, do you want to bring a motion regarding the source of the bail money? Which of course they did, and they had that ability. But you would still have the ability to deal with a situation like that, and you might not deal with it in such a rote way as always imposing the scheduled bail. Okay.
All right, so we're going to move on to our next speaker, which is Max Szabo. He's founder of the Szabo and Associates in San Francisco. He led several successful reform efforts as deputy district attorney under DA George Gascon when he was San Francisco's DA, and he also consulted on Gascon's Los Angeles County DA campaign. Max first spoke to our club in March 2021 about reimagining criminal justice. His comments were summarized in our April 2021 newsletter on enhancements, the death penalty, bail, survivors of crime, and other issues, if you want to follow it up. But please welcome back Max Szabo.
Thank you so much for having me, and appreciate your interest in these issues. Sorry, I'm not able to show my face today. I'm traveling, so please you can excuse the impersonal nature of this call-in, but happy to be here with you all nonetheless. I was asked to speak to a number of things, namely Proposition 47 to begin with, because it's sort of entered our dialogue most recently once again, with people claiming that it's responsible for all manner of issue, everything from theft to organized retail theft, property crime, basically everything short of global warming has been blamed on Proposition 47. And I kind of wanted to take a few minutes just to provide a little overview about what Proposition 47 did, and to provide a little context and provide some statistics as well. So in 2014, the voters in California overwhelmingly passed Proposition 47. Proposition 47 had really two principal components to it. First is that it made felony possession of drugs for personal use a misdemeanor instead of a felony. So that means if you're caught in possession of drugs simply for your use, not drug dealing, it is that would now be a misdemeanor instead of a felony offense. And there are so many reasons why that was an important change to make. And I'll touch on those in a moment. The other big change was to increase the felony theft threshold. So if you engage in theft, and that's not robbery and that's not burglary, if you simply engage in theft and you steal something that is at the time the felony theft threshold was, I believe, either 400 or 450. Sometimes I mix it up. If you were to steal, for example, more than that, let's say we were to steal something worth $500, that would be a felony. The problem with that is that we did not change the theft threshold to keep pace with inflation. So if you look at, certainly more conservative states like Texas, South Carolina, and others, they have a felony theft threshold of $2,000. So there's a lot of people that claim that increasing that felony theft threshold is what has increased property crime. There's so many reasons why that does not make a lot of sense, but we can talk on that in the Q&A portion if that's something that folks would like to get into more so. The Pew Charitable Trust has studied this, and they've looked at, I think, about 32 states across the country that have raised their felony theft threshold. Those studies have all shown that there was no market increase in property crime as a result of raising the theft threshold. And frankly, here in California, since 2014, if you want to go to the Department of Justice's Open Justice website or web portal, the statistics show that statewide property crime has gone down. So that raises the question, well, what is happening with organized retail thefts and some of these other things that we're seeing in the news? Keep in mind that, since the theft threshold was raised to $950 to keep pace with inflation, anything that is stolen that's above $950, like a Louis Vuitton handbag, that would still be a felony, for example. Again, and keep in mind too, if you're burglarizing a store, so if you're, breaking into a store when it's closed, for example, and engaging in a commercial burglary, that is still a felony. If you push somebody if you use force or fear in order to take property, that is a felony. That's a robbery, and it can actually be charged. Have very serious consequences associated with it as well. So, statewide, we have not seen property crime go up, but in some jurisdictions, we have seen property crime go up. Generally what that means is if you have statewide statistics associated with a statewide measure, but in individual localities, you're seeing increases in certain types of crime, that really requires local leaders and local law enforcement leaders to look at what the local causes are. Are there local approaches or local things that are happening in the community that are driving these types of increases in crime? Or, is there something that we can do differently, as opposed to let's change a state law? Those are the basics about Proposition 47. I also want to touch just briefly on, changing the reducing felony drug possession from a felony to a misdemeanor. Advocate, and I would proffer that one of the reasons California has such a problem with homelessness, it's not, certainly we have a housing crisis that's absolutely lent itself to that. There's been an opioid epidemic, largely born of big pharma as well, which I think has, had some implications as well. But, for decades, we applied felony consequences to low level of behavior associated with drug addiction. And we, basically gave, hundreds of thousands, if not millions of people, the scarlet letter of a criminal conviction simply for being addicted to drugs. We didn't treat their addiction. We said, you were addicted, and, a lot of them were given felony convictions as a result. As you may know, a felony conviction is a huge barrier to employment and housing. And, no shocker there. The barriers to getting a job or a place to live are, significant contributors to homelessness. They are also primary factors that drive recidivism, which recidivism being rates of reoffense. So, California is, has sort of the dubious distinction of being the nationwide leader on tough on crime. We really led the way, and the rest of the country followed. And today, we're leading the way on homelessness largely. And, I would certainly offer that one of the reasons that we have such a huge homelessness problem is we saddled so many people with criminal convictions, which, limited their abilities to find jobs, places to work, and that in turn had cascading consequences for our community and for homelessness. So that's Proposition 47 in a nutshell. Certainly, I'm sure there'll be additional questions that we can discuss in the Q&A portion. But keep in mind again, grand theft is still a felony. There's a felony crime for organized retail theft as well, which was created, I believe, in 2017 or 2018. And it was subsequently modified again, I believe, in the last legislative session. There's also conspiracy to commit theft if you're working in concert with one or more persons. But moving on to, I believe I was also asked to speak to some of the reforms that have been made in LA County by District Attorney George Gascon. I'll just touch on a few of them just to try and keep things short. I'm going to talk about enhancements again, life without parole, juvenile justice, and misdemeanors. I'm going to start with misdemeanors, if that's okay, since the distinguished judge who joined us kind of touched on this, I think, with his comments about bail in particular. But in Los Angeles County, the district attorney has declined to charge first-time misdemeanors for a variety of low-level offenses. These are, things like driving on a suspended license, and some other, another list, some other items as well. I'll be sure to pass along a list here between sort of my remarks and the Q&A. I should have put that list together. But misdemeanors make up about 80% of cases in our entire criminal legal system across the country, and they divert massive resources from the prosecution of violent crimes. What's more, and what's really important, is that prosecuting first-time nonviolent misdemeanors actually significantly increases the risk of rearrest. This is according to a multitude of studies that have shown this. And a recent study actually shows that people who were arrested but not prosecuted for low-level nonviolent misdemeanors were 58% less likely to commit another crime in the following 2 years. And even more, I think it was like 60-something% less likely to commit a violent offense in the next 2 years. So, a lot of times the criminal justice system, involvement in the criminal justice system, it doesn't actually deter crime. Sometimes it actually can breed more criminality. And, the reason for that can be a number of things. A lot of people don't have the ability to take time off from work to go to attend a court date. And all of a sudden, they get charged with a low-level misdemeanor offense, and they have to take time off from work. Well, maybe now they don't have a job anymore because they had to leave work in order to go to court for a low-level offense, such as driving on a suspended license or otherwise. So, I would just say that that's one of the reasons why you're seeing a number of these low-level misdemeanor offenses not being, first-time low-level misdemeanor offenses not being charged. In terms of, juveniles, You've probably seen a lot about this in the news recently. It's certainly a controversial thing with some people, but again, the data suggests that if you get a young person involved in the criminal justice system at an early age, they're likely to be involved. Their likelihood of a lifetime involved in the criminal justice system grows significantly. Involvement in the juvenile justice system or the criminal justice system has never been shown to reduce someone's likelihood of future criminality, but it has been associated with certainly increase in trauma and increased likelihood of recidivism and being involved in a future time in the criminal justice system. And then additionally, one of the things about juveniles is that, again, it has certainly been correlated with higher rates of recidivism and trauma. And, this is largely because fear destroys our capacity to learn. And we know that isolation, if you take a child and you put them in a concrete box, it activates the harmful stress hormone called cortisone in our bodies, and that actually leads to lasting damage. Kids also have a unique ability to rehabilitate and grow. We're not talking about somebody who's 40 or 50 or who has been involved in the criminal justice system for a long, long time. Kids' brains are still developing until some arguably between their 25th and 30th birthdays, and if they have the ability to change where more individuals who have been in the criminal justice system for a longer period of time and involved in simply do not. So I guess just one other thing I would say is, the rational, I think for those of us who have kids, right, if you have a teenager, you probably know they don't necessarily make the most sound decisions with, thought to the, with thought to what the consequences may be. But as they get older, that decision making, matures. And certainly, the question is, should we, take someone who's younger and who, arguably does something, horrible and commit them to a lifetime of criminal justice or a lifetime of being involved in the criminal justice system. If you, if you put them at, 17, 18, 19 in adult prison, they're going to spend their formative years around much more severe and hardened, offenders. And that's going to be what they know and what they learn from, and that's where they're going to do that's where they're going to have their development. We know when you do that and they come out of the criminal justice system, they're more dangerous, or not all, but very frequently they are more dangerous, and that can be that can result in creating more victims, not being a benefit to society.
So I'm going to move on to Paul Szabo. In March of 2020, Paul Szabo was elected to be member of the Los Angeles County Democratic Party for the 66th Assembly District. From 2015 to 2021, Paul served as Deputy District Attorney for the Los Angeles County District Attorney's Office. Paul currently serves the state of California as Deputy Attorney General for the California Department of Justice, as DOJ, Special Prosecution Section, specializing in officer-involved shootings. Assembly Bill 1506, approved by Governor Newsom in September 2020, created this division within the Department of DOJ to review the use of force policy of the requesting local law enforcement. The bill made the AG the state prosecutor to investigate incidents of an officer-involved shooting resulting in the death of an unarmed civilian. So this is what Paul is involved in right now. So please welcome Paul Szabo.
Hello, everybody. It's great to see everyone. And I know it's COVID, so we haven't been able to see each other. And I definitely want to recognize all my former colleagues here that are running for judgeship. I want to wish you good luck. And they have extensive experience in regards to criminal justice and different aspects of the criminal justice system. I myself have experience serving in Compton for about 4 years. I did misdemeanors for a long time as well as felonies. all the way up through, from suspended licenses to homicides. So I definitely know what Judge Long was talking about and Max is talking about, and I have different experience when it comes to different charges and how courtrooms operate and whatnot. But we can get into that in the Q&A. But specifically, my background now is working with officer-involved shootings. So specifically, when people ask me, they're like, "Hey, do you go out to all different shootings?" That's not the case. The specific cases we handle are the ones where unarmed civilians are killed during a police officer shooting. So from my perspective and my team, we handle those in 10 different counties for our area and our jurisdiction. And currently, one of the cases that you guys may have seen is the Burlington Coat Factory where the child was shot and killed. So we handle those specific issues. Now, in regards to how the cases are investigated, I just want to give you guys a broad, like 10,000 feet overview of how it works. And I'll get down to the nitty gritty really quickly. So when I joined the team was basically stood up in July because of AB 1506. All of us, the majority of us, are trained in going out and seeing a specific police officer shooting incident or locale. So all of us went through different types of trainings, 2 different sessions where police officers actually are trained on the use of force. So we went to 2 different academies to actually experience what actual police officers are learning to deal with de-escalation with individuals that are mentally disabled in certain functions and whatnot. And we were able to see exactly how they operate when they get to a scene like that. So based on that specific training, we were able to look at the totality of circumstances before we go out to actually investigate these scenes. Now, what we do is we rotate on a 2-week cycle and we're on call. So if there's a shooting in one of the 10 counties that we cover, we actually do roll out. And when we say roll out, is we actually go to the shooting scene. We do a complete walkthrough with our own investigators in regards to what happened. And we develop the scene, we develop the investigation. And if based on our investigation, if charges are warranted, we'll actually file criminal charges. But if not, we won't. So in a nutshell, we handle a very narrow portion of what we normally would see in an officer-involved shooting. So if you saw something with LAPD getting in a firefight or they're shooting, the local DA might handle it. But if a specific incident occurred where an unarmed civilian was killed, we step in and we go called out to the specific location. Now, if there's a conflict, for instance, every DA county or district attorney county has their own investigators. So let's say those investigators were to get in a shooting. Because it's a conflict for that certain county, that would come to us. And we would handle that specific case and we would do the investigation to see if the charges are warranted in that particular case. So my section, we handle that specific, topic as well, but there are other things that we cover that a lot of people don't realize, to include human trafficking, fraud, huge incidents of like big marijuana cases, anything that happens to be criminal or needs to be tried for prosecution. And we also deal with environmental crime. So the oil spill out in Orange County, that's a case that we're handling as well. So I know that Judge Long and Max talked extensively about the criminal topics. So instead of going on and on, I think I'll just cut it short here. And if we want to go into Q&A, we can get specifically into any of the questions that the members might have.
That's fine. If you did want to give, I mean, you've been DA, Deputy DA, was just a couple months ago, right? The transition?
Sure. I left in October. So, talking about misdemeanors and just how Compton operated in my experience with, I ran a misdemeanor calendar. So I was one of the prosecutors that might have appeared. I haven't appeared before Judge Long, but I would be a person that would be in front of a judge. So in my experience, this is even before Mr. Gascon took office. Compton was a little bit different in the sense that the volume of cases is so high that in order to do the right thing to move cases along, we were actually doing a lot of things that we're doing now. So for instance, driving on suspended license, those cases are still charged because of the fact of the background of the suspension, not only for DUIs or for domestic violence or something of that sort, but those cases were still charged. Now, based on the charge itself, instead of convicting the individual or defendant who was brought before us, what we would do is we give them time. So say, hey, in 6 months from now, if you get your license, we'll dismiss the case. So we do that type of stuff. For drug cases, if it was something that had to deal with paraphernalia or small amounts of drugs or marijuana, what have you, we'd most likely dismiss those cases based on the facts, right? And the cases that, especially for misdemeanors that we took seriously, were the DUIs and domestic violence. So those are the ones that were focused on to make sure those the victims and the individuals in the cases were protected and the defendants were treated fairly and equitably. So those are very specific things that we did before a lot of these policies came on board. And I think a lot of people don't realize that, because, you know, Compton is just, it's its own beast, and a lot of DAs understand that as well. But a lot of things that, and the policies that were, you know, being talked about and said that were being implemented now were being done for a while in Compton. So that was my experience with that. Now, when it came to bail, a lot of people think that zero bail means that everybody's basically like, oh, no, which is not the case. So on violent crimes where it's murder, it'd be rape, sex crimes, domestic violence that are felonies, those things, that bail is still there. Now, for low-level offenses, it's zero bail. So those individuals can go home. They get cited out, so they're not held based on certain types of money. Now, if on a particular case, for instance, let's say we have, it was just a regular domestic violence case that's a misdemeanor, the prosecutor might, based on the circumstances of the case, argue for bail because of the specifics of the case and the background of the defendant and maybe the history of it. But in my opinion, and, you know, with my experience, a lot of it had to do with the case and the individual of the case. So it wasn't a blanket issue or blanket policy that we instituted. Every case that we looked at was specific, and every case was different. So different things apply to that particular case. So we wouldn't do, just because it was domestic violence here and there, we wouldn't do the same thing. We'd look at the case, we'd look at the facts, weigh the facts against the victims, against the defendant, and see what the issue was. Now, in my experience, I've had cases where there would be bad stops, or I thought police officers were corrupt or did the wrong thing, even though there might have been a bad crime. I would dismiss the case based on the conduct and doing the right thing. So a lot of prosecutors do this, and, you know, based on the media and things like that, there might have been, I think there's a bad rep because of what's going on and the light of things that are going on. But there are a lot of individuals in the courtroom, to include public defenders and the bench, that are doing as much as they can to make sure that there's an equitable result in the court. So based on my experience in Compton and me being there for about 4 years, those are things that I ran into and that I can opine about. Now, if we want to talk about the enhancements and, you know, things like that, we can do that during the Q&A and just the overall criminal justice system, man. But did you want me to address anything else before we go into Q&A?
No, we can go in.
Okay.
We can go on to Q&A. Okay, so what we're going to do is have all three of you up. And so one of the common things that wasn't from Tom Long, and I don't know if you can even talk about it or give an opinion, but so Max, are you still on with us?
Yes, I'm here.
Okay, great. Okay, so we're gonna, there's a little background there, but we're gonna move on to Q&A. And so both of you were actually going to talk about enhancements. So, and that was one of the changes that did come down from George Gascon. So maybe that could be our first question in terms of what your view is on the change in enhancements. So I'll let you go first, Paul, and then we'll have Max.
Now, I have a differing opinion in regards to enhancements. And, you know, in the beginning, I think there was a wholesale, you know, there was an issue, in my opinion, in terms of wholesale getting rid of them. Now, when it comes to hate crimes and certain heinous crimes, I think enhancements should be used. Every other law enforcement agency and prosecutor agency that I know of still uses them. Now, for instance, in financial crimes, right? Especially at the AG's office, there are certain crimes that may get a certain triad of punishment. When I say a triad of punishments, there's a low, mid, and high term on a prison sentence. And Judge Long knows this, Max knows this as well, and everybody else and my former colleagues know that sometimes it's 16, 2, and 3, 16 months, 2 years, 3 years. So when it comes to those kind of things, it might be an appropriate punishment. But for instance, there's enhancements when it comes to the dollar amount of fraud, right? So we might deal with cases that are close to $100 million in fraud. Now, do you think it would be appropriate to give this guy 16 months in state prison when he's been doing it for 25 years and he's been basically taking a lot of his money? No. So based on those circumstances, I think those enhancements are appropriate. I think there were certain redundant enhancements that were in the penal code that I think they're duly taken away now, but I think they're appropriate for certain situations. And I think that needs to be weighed by a prosecutor and the agency itself before those are actually instituted. But a wholesale dismissal of them and not using them, I think I don't think that's a great idea, because every case, like I was saying, is different. And certain crimes, like I think Max would agree with me on this one, like certain hate crimes, they need enhancements are appropriate. Now, there might be situations where on an individual case, you might have a young defendant who committed a crime. He might be eligible for certain enhancements and whatnot, and not using them because he's younger, and giving him a chance to rehabilitate and get out in quicker time. I think those might be different situations where enhancements might not be appropriate. But I don't think a wholesale dismissal and getting rid of them is a good idea. So that's just my 2 cents on that.
Okay. So a few things I in terms of sort of hate crimes in particular and financial crimes, a whole list of actually additional offenses. There was changes made to the initial complete ban on enhancements, which does enable enhancements to be charged in financial crimes and hate crimes and a number of other types of situations. So there are, under sort of the existing charging regimen out of the LADA's office, the ability to charge enhancements in a number of the types of offenses where, enhancements, may be necessary because of some of the, the issues that Paul mentioned. Just generally, I think the issue over enhancements comes down to what kind of criminal justice system and what kind of society we want to have. Do we want to engage in retribution, or do we want to engage in accountability and enhancing safety? Between something like 1990 and 2006, California increased sentence lengths by 63%, and we had a prison population in California of 90,000 people roughly in 1990. 3 strikes came up in 1993, I believe, 1994, and was passed thereafter. 5 years later, in 1999, the prison population in California was 160,000 people. We have to look very, very, very carefully at the implications of sentencing enhancements. They are the vast majority of the people that are in prison on enhancements are people of color. And there's a question: is this actually making our community safer? The available data says nothing of the sort. That these enhancements do not increase safety. There's an initial incapacitation period, right, where somebody is taken out of the community because of the danger that they pose. But when we're adding 5, 10, 15, 25 years onto an existing sentence that's already long, for robbery, you're looking at 4, 5, 6 years. That's not a cakewalk in state prison. That's not a short amount of time. And the rationale behind sentencing enhancements is, we implemented a whole barrage of tough on crime policies under the guise of, hey, this is what we need to do to make our communities safer. Really, they were actually a response largely to a number of crimes involving very high profile crimes, including polyclass, for example, which politicians responded to in the 1990s with 3 strikes and some of these other enhancements. There was no data that said that these enhancements were going to increase safety, and by all points, they did not increase safety in California. So the question remains: what is the in terms of certainly a financial cost associated with enhancements? There's certainly a societal, a social cost associated with enhancements in terms of specific communities that these are largely impacted on. And when we don't see an actual benefit in terms of any sort of statistical data or any sort of statistical analysis that's ever shown that enhancements somehow create safety, we really need to consider what these policies do lead to. And it's really mass incarceration. Enhancements are the fundamental basis of mass incarceration in California. They are the driving force behind mass incarceration. And a lot of prosecutors and a lot of people in criminal justice reform talk about, hey, we need to, we have to fix mass incarceration, but they're only willing to talk about low-level offenses. And the reality is we have to look at sort of the full picture of what our criminal justice system has done over the past 30, 40, 50 years. And then we need to make decisions not based on the hyperbole and, the headlines and Fox News, but actually based upon, what we know the implications of those policies to be. And there has never been any sort of study that has shown that enhancements are making our community safer. So I think that those are some of the major points I would make about enhancements generally. I think in addition to that, you got to look at also a lot of people invoke victims, and you hear very frequently people say, well, what about the victims? What do the victims want? Is that justice for the victims? I find that rhetoric to be very concerning when you actually look at polling of victims of crime. There was a poll of victims of violent crime in Los Angeles County recently, and it showed by a margin of 2-1 that victims prefer, healing and rehabilitation, or policies that promote healing and rehabilitation, and prevention over simply more, longer periods of incarceration, and policies that exacerbate and increase incarceration. Now, of course, we have to take victims as we find them, and victims are going to be very different depending on where they are in their journey, right? If somebody just lost a loved one, or they're still in the middle of the disposition of their case, what they're going to want at that moment in time is very different than somebody 10, 15 years later, when they get to look back and sort of look retrospectively in terms of what would have helped them and what they want and what they needed to heal. But the reality we do know is that most people don't get healing out of putting somebody else in the box. So we have to be very careful about, invoking victims to make the case that we need to put somebody in prison for a longer period of time because that's what victims want. We certainly need to be careful about making those statements because that's somehow going to increase safety. There are a whole host of other implications of some of these, tough on crime or policies that are of the tough on crime era.
Tom, did you want to say anything, or should we move on?
Well, I guess I just briefly make the comment that I think a lot of these issues raise the question of fundamentally, what do we want our incarceration rates to look like? And on the spectrum ranging from countries, say in Northern Europe and Western Europe as one end of the benchmark, and countries like Iran and China at the other end of the benchmark, currently our rate of incarceration, if you look at reports by Human Rights Watch, looks a lot closer to Iran and China than it does to Western and Northern Europe. And so I guess the question this all poses for us is, what do we want out of our justice system?
Very good. Okay, we're going to move on to some questions from the audience here. Heidi, you had your hand up first.
Hi, thank you. I have sort of an off detour question that I'm interested in, which is that I had understood that a lot of prosecutors' offices determine bonuses and pay scales in order to try to make it objective in the workplace by reference to objective statistics that consist of conviction rates. And that therefore the financial incentives for our prosecutors at every level is really to move forward and convict and get the longest sentences possible. Is that still accurate? Is that how our DA's office or city attorney's offices work, or have they changed that, please?
And I can answer that question. Heidi, in regards to what you just stated, if it's based on that, that is unethical. So that is unethical. So if you're trying to say that, I get paid more for having a higher conviction rate, or I get promoted based on that, would be completely unethical. Yeah. Because you're basically trying to determine, your cases and trying to get you're basically trying to get a guilty just to get more money, right? So in not so many words. And that's not the case. That has not been my experience. And if our county did that, I would have left a long time ago. So, we definitely don't use that. And if that's the case, I definitely haven't seen a cent of it.
Great. No, I'm happy to hear that because I had understood that from some quarters, and that was a problem. Just very briefly, also, the most recent statistic I saw said that California is one of only 7 states in the nation that has a retroactive racial impact 9-to-1 disparity between Black and white incarceration. I think that study just came out last year. And I didn't know whether our DA's offices or our city attorney's offices or our courts had undertaken any sort of retroactive racial impact analysis on how our penal code was being applied, particularly on low-level nonviolent offenses.
In my experience, I can't speak to that because I don't know if anybody has done that. Most of the jurisdictions, so different courthouses deal with the demographics of a certain area. So, your demographic in Compton is going to be a lot different from LAX, right? And the people who live out there, or Torrance, or in the Valley, or, in Lancaster. So I couldn't tell you, and I can speak to that. I don't know if Max can, dealing with the campaign and at a higher level. But for me, I've never seen anything like that. I don't know if Judge Long has, but I have not.
I have not either, and I don't think the court system is in a position to study that. And keep in mind, from the criminal point of view, each of our experiences may be limited to the courthouses we were in. I'm in Compton now, but civil, my criminal experience was all in Bellflower and Downey, and it was very different between Bellflower and Downey. Now, I will say we every now and then see people running for judicial office. I think this is fairly rare, but they'll announce their conviction rate as a DA as part of their qualifications. But I've never heard of the concept, and I agree with Mr. Szabo. I think it would be unethical for people to be, for payment bonuses or performance reviews to be focused on things like conviction rate. I've never even heard of that. I would be extremely surprised, and I would agree that it would be unethical.
Okay. I would also have to agree that it would be unethical, Heidi. I do think, however, that for a long time, conviction, one of the barometers of success in a lot of prosecutors' offices was, conviction rate and, length of sentence, right? How many years you were able to get, out of on a sentence. It's never been, have we prevented that person from, once they got out, from reoffending? Did we apply the correct intervention, right? So you are seeing a shift in a lot of modern prosecutors' offices to shift sort of the barometer of success. And that's, I agree that it's not that, automatically people are getting, bonuses or any sort of payment or promotions associated with that. But for a long time, that has been, what was sort of the, a barometer of success is how long and, how often and how long you were able to sentence somebody to prison.
Thank you.
Okay, and I just want to mention Heidi is running for Los Angeles City Attorney, and she'll be posting her information. Okay, Tony, you're next.
Thank you. I have a twofold question, one focused at Mr. Long and the other one for Max. Mr. Long, I'm wondering, I think most Democrats support eliminating money bail, at least as described here today. And I'm wondering if the judge or the other speakers have any assessment about how much the criminalization of poverty has determined the rate of incarceration in our state. And then just to get it in so I can get my questions out of the way, I'd also like to ask Max exactly what changes to enhanced sentencing have been made. I know initially there was an attempt to remove all enhancements, but then victims groups were concerned about hate crimes and elder abuse and other issues. And then that changed. And then there were some changes that were addressed by the court, which the court stopped the district attorney. So I'd like to know what changes actually have been made on enhanced sentencing. But Mr. Long, please go first.
Well, okay, in my experience being a judge assigned to misdemeanors, some felony arraignments, but largely misdemeanors in Downey and Bellflower, I saw a lot of what I would call criminalization of homelessness, or at least in the charging aspects, criminalization of homelessness. I literally had to stand up to look over the piles that were in front of me of cases that were being pursued, involving drug paraphernalia possession, involving things like sleeping in a drainage channel. And when you give a homeless person a notice to appear in court, funny thing is, a lot of them don't have good calendar diaries and they don't end up making it to court. I've heard of some court systems going so far as to find ways to communicate, if the person has a cell phone, finding ways to send them a text reminder or things like that. But the bottom line is you get a lot of people who fail to appear. And then what the routine of the courts was, for example, the drug paraphernalia possession, the scheduled bail when I was in the assignment was $250. And what the practice was, well, they failed to appear, so we're going to raise the bail to $30,000. And of course, the reason you're raising it to $30,000 is that causes the sheriff to pick up the defendant. And then they end up in jail. And then as one DA was candid enough to acknowledge to me, that then allows you to negotiate a plea bargain that gets a conviction. And because they're in jail. And one of the departments I showed up in had a rubber stamp that said failure to appear, bail set at $30,000. And I used the rubber stamp a couple of times. And then I thought, I'm not going to use it anymore because I don't know why these people have failed to show up. And I'm just going to leave the scheduled bail at $250 on this huge pile of cases I have that are drug paraphernalia or sleeping in the drainage ditch kind of cases. And a DA complained to me at one point that that was going to mean that all these cases were going to age out. To which, of course, my response was, and your complaint is? What is your complaint? I only have an anecdotal experience I can give you from the 9 months I spent in 2 different criminal assignments. And what I saw in one of them was what I just described. What I saw in the other was a contrast. And it was odd there was so much inconsistency. But in the other one, there was a contrast in the sense that many more of those cases were being dismissed. Many cases were being diverted. People who had drug abuse problems were being sent to drug abuse programs. And if they performed well and attended and showed back up at their court appearances, they would get the case dismissed without any conviction being on their record. It's not just a felony conviction that's a scarlet letter, as Mr. Szabo suggested. I think that misdemeanor ones can be as well. And that, once you start someone down the path of having a criminal record, for good or for bad, you're starting them down a path where society is not going to deal with them in the same way. And it's going to be very, very hard. Can they get an expungement? It's not easy to get an expungement. They can, and it'll take time, and it's something that can happen. I saw it happen in misdemeanors. That was one of the things I most enjoyed doing, was dealing with the expungement applications. How it works in felonies, I don't know. So my experience is just anecdotal, but I did see, at least in one courthouse, not in another, not so much in Downey, more in Bellflower, I did see a considerable amount of what I would call the criminalization of drug addiction and homelessness.
Paul, did you want to?
Yeah, so my experience is a little bit different from Judge Long's in regards to the criminalization of homelessness and drug addiction. For us, I want to say that the prosecutors, the defense bar were working together to solve those types of issues. So especially as a prosecutor working in misdemeanors, if we had a case that we thought, so for instance, an example I would use is, I got a case where an individual bench warranting is not showing up to court, and the charge was basically it was a theft case, and I was wondering what it was. Basically, the individual took a shopping cart from one of the big box stores, put recyclables in it, and then he was cited for it. When I looked at the case, for me and everybody in the court, we're like, why are we even doing this, right? We didn't want to criminalize that. So we dismissed the case. There's a lot of those issues that come up, and there's a lot of cases like that. And in my experience and in my courtroom, the one that I was running with my counterpart, those cases for the most part disappeared, and we didn't deal with those cases because we knew for a fact that if we try to cite them, or like you were saying, Judge Long, they don't have calendars. They don't have, a lot of them don't have cell phones. They're trying to make it, paycheck to paycheck, if they even have one. And we're basically spinning our wheels for nothing, is what I'm saying. So in my experience, we always took that into consideration before we handled the case, and we cleared the calendar as best we could in light of certain things. So, but if there were victims involved where restitution was, to take place, then we kept those cases because the victims need to be made whole. And if, for the most part, a lot of the individuals can't pay, and we tell that to the victim, and for the most time they would say, okay, I understand, and we close the case. Everybody had an understanding about it. So that's how we dealt with the majority of the cases for misdemeanors, at least. Now, felonies are a different story. And, I can get into that later, but for the most part, just addressing what Judge Long was saying, and in response to Tony's question, in Compton, we were very, very cognizant of what we were doing in regards to people who couldn't, I guess, pay fines and whatnot. So,
but aren't you, and so maybe Max will follow up here too, but aren't you concerned where Judge Long is saying one city is different than another city in terms of how they're dealing with this? I mean, do you guys look at each other and say you're doing it wrong? Like doctors, have you seen this stuff with doctors? A doctor is doing malpractice. Do you guys look at each other and say, I mean, how can it be so different in one city versus another city? So
sure. And, and then that's something that leadership has to address. And then what I say is this: every case is different. Every case is individual. And, I can't say that the actions that we were taking, how we were dealing with cases, is going to fly somewhere else, right? In Lancaster or in LAX or something of that sort. Now, is that a policy and a management issue? Probably. I can't address that, obviously, but how we were doing it through our leadership, it worked, and it addressed the issues of our community at the time. And that's it. It could be done better, and it could have been done better in other places as well to address things in Bellflower and such. Yeah, probably. Yeah.
Max, did you want to pipe in?
Yes, this has been a long-standing concern, right? People call it zip code justice, right? Depending on where you live, you get a different sort of outcome. The office recently changed this so that they're going to have a central filing unit instead. This is something that's going to take some time, but they're working on having all cases filed locally by one team, irrespective of where across the county the actual crime occurs. The idea there is to make sure that there's consistency in charging.
Okay. Tony, did you have something else, or I'm going to move
Well,
on?
just to follow up with Max about exactly what changes have been made to enhance sentencing by the.
Yeah, I put absolutely, Tony. I put a link to the specifics because it's pretty, it's pretty insidery, and I don't want to necessarily take everyone's time by going through code sections, but generally, where there is a vulnerable victim involved, the general rule is that is where a enhancement is available, right? So hate crimes, crimes against elder adults, crimes against kids, that's where you will see the ability for financial crimes, fraud as well. That is where enhancements have been allowed to be filed. And there's a couple of other there's including for GBI and some other circumstances as well. You can take a look at the policies that I put in a link to the policies, which is in the chat. There's quite a bit there. You also asked about the recent litigation and the impact that had. So the basic that case is on appeal currently, but the way that it's being interpreted currently is that at least for now, charges or enhancements that were previously charged before Gascon took office, as you may know. When Mr. Gascon took office, he announced that he was not only going to be proactively not seeking enhancements, he was going to make sure that both cases that were currently pending were going to be that there was some semblance of equal justice, right? If you were charged I think it was sworn in December 7th, if you were charged December 6th, that you would have the same sort of charging scenario as if you were charged December 8th. Well, a judge basically said that in applying that policy across the board, the district attorney, they were not using discretion in a case-by-case basis, and the court found, the circuit court found that that was not appropriate, and that decision is currently on appeal, and those issues are present both in that case and also in another case that the Court of Appeal is currently considering. Basically, whether or not they can dismiss those cases, the enhancements in previously charged cases.
So just to wrap up real quick, just for a specific thing, enhancements for involving the use of a firearm. I think we'd all like to see gun violence reduced in our communities. In what way are there still enhancements for the use of a firearm?
Generally, no, is my understanding. But I think the premise of the question is sort of not necessarily associated with enhancements, right? I don't, if your goal to preventing and crime is to charge something after it's already happened, you're doing nothing to prevent the crime. If you actually look, just search Department of Justice deterrence, what you'll see is that people's perceptions about whether they're going to get caught is a far more effective deterrent than the length of prison term that they're going to actually be faced with. So again, we have to sort of disassociate the idea that sentencing is an additional term of imprisonment is somehow going to deter crime. It's never really been shown to work. Good example is the death penalty, right? The death penalty has never been shown to be a deterrent, because when somebody goes and commits heinous murder, they're not really thinking, oh, I'm going to get the death penalty for this. It's just not how deterrence theory works. People don't think about the consequences. They think about whether they're going to get caught for the crime. They don't think about how long I'm going to get in prison for the crime that I commit.
Okay.
Thank you.
Thank you, Tony. I just want to say, on the chat, people have been wanting to, I have said that some of the candidates, that are running for judge should talk, but we'll have them talk later, at another meeting. But what they should be taking from our meeting is what is the topics that people are interested in that we're going to ask them about. And one of the things that has come up at other meetings is, should a candidate or someone who is either running for a new position as a judge or DA or something, should they take money from the police union? So this has come up before, and I guess I would like everybody's on our panel's position on that. Should they be taking money from the police unions? So we can start with Judge Long.
Well, as a judge and having, I have to run for re-election, but I in my experience, I haven't had any opponents, so I haven't had to take any money from anybody. So my own comment would be, I would anticipate taking no money from anybody with respect to any of my campaigns. I wouldn't expect judges to take contributions from people who might appear in front of them as witnesses or people who might appear in front of them as advocates. So I think a judicial candidate has to be particularly careful. As to what other candidates do, I wouldn't comment on that.
Paul, you want to go next?
Sure, I can address this. I think it's going to depend on the candidate and what that candidate's values are, depending on what type of situation they're in. So I think it's case by case, like I was saying, for other things, and other individuals would take it and some not, based on their values and what they believe in. So I'll just leave it at that.
So would you?
I'm sorry?
So, but you could answer personally.
Yeah, so if, like, for instance, just to address the whole issue, right? And I think the important topic here, I think, in regards to a specific question, is that before I even answer that, is elevating the conversation from today, right? I think we're dealing with a system that's very complex, right? Judge Long is one pillar of the criminal justice system. My office is one. The DA's office is one. You have Department of Mental Health, you have probation, you have the prisons. So the problem that we deal with is not only, just in one section of the DA's office. It's a problem that needs to be dealt with and addressed by the entire system, right? So one of the things I wanted to address was, like the slogan of defunding the police. I think that is, in my opinion, I think that's a bad slogan because we don't get to the core of what the issues are, right? And I don't, for the most part, even the proponents, I don't think truly believe that that's the right way to do it. To say that the DA's office has the entire burden of changing the criminal justice system, I think it's unfair because for me, at least, the criminal justice system is, for me, at least, we need to make sure that people don't enter it. And then when people are leaving it, they have the resources not to come back. And I think that's a multi-pronged approach by everyone based on the situation, from the Board of Supervisors to legislators, to individuals that are dealing with the criminal justice system. And I think that's where the focus should be. A lot of the specifics in what we deal with and what social media and just media in general focus on is just the DA's office, right? They want a law enforcement official to make policy for the broader public and to solve the issue of the criminal justice system. And I think that's unfair. And I frankly, I think that's too hard of a lift from one organization. I think everybody needs to come to the table in order to recreate the slogan. I think a better slogan might be a community-centered criminal justice approach or reform. We need to think about who we're actually affecting, which communities we're affecting, right? So for instance, with my experience, I sat on a police advisory board on the West Side and on a neighborhood council, and I chaired a public safety committee. And I was able to see firsthand the crimes that occurred, right? And when you see the statistics, for instance, reporting, right? You see crimes being reported. If a police officer gets to a scene for a burglary or theft from a vehicle and they don't take a report, that doesn't get reported. That happened multiple times. So if we want to say that theft is overall down, when I was there, it was not the case. When I go to these meetings and I see the statistics or the numbers they capture versus what I heard from the constituents and just people in my neighborhood, it didn't match up, right? So what I'm saying is I think I have a unique view when it comes to the actual, what's actually happening on the ground and getting to the point of taking money from candidates, right? I think if an individual decides that, like, for instance, ultimately it's like this, and how I'll explain it is, if you need change in a police department, I think a lot of folks right now are asking, what are we doing on the police side? Are we defunding them? Are we taking money away from them? But if you start taking them away, like you start taking money away from the department, that's less training for police officers, right? If you train them less, they don't have the confidence to de-escalate situations. They don't have the training to be able to handle certain individuals that they see as a threat. If they had more training based on the experience that they had going through the training, I went through 2 different academies about police use of force. The more they do it, the better at it they get without having to use the force. They understand what's a taser, right? How to use a taser, what are the options? So based on that, I think those are the issues that we should focus on, as opposed to asking candidates, are you gonna take the money or not take the money? So I think that would be my answer.
Okay.
Yeah, at this point.
Yeah, that's, I will say, in the case that you had talked about earlier, that the AG is over, the case where the officer killed the young girl in the dressing room, he had just gone through training. Right.
Yeah, so for me, just to answer the question, I'm not going to be depending on, law enforcement support, but I will definitely work with local police and other city councils in order to make sure that we have the best trained police force to deal with certain situations and make sure that they have the right outcome so everybody goes home safely, right? Police officers, our neighbors, people involved in the situations, and periphery. So I think that's the most important part.
Okay, Max.
So a lot going on here, but I would say, look, it's just like any other special interest, right? What does the money speak to, right? What is, when traditionally police unions, police officer associations have been, one of the top primary opponents of reform. And, when we talk about, so, I think that that's something that needs to be kept in mind, right? I don't necessarily think that I'm not somebody who says, oh, they shouldn't be allowed to give, or you should, or otherwise, right? I do think it's a different story when it comes to prosecutors. I think that prosecutors should be forced to recuse themselves if they accept police union money, because I think what happens is it creates a conflict of interest, right? If you're a prosecutor and you're investigating the members of the police union who you have a financial relationship with, that's really problematic. It's just like any other conflict of interest, right? If you have a political or financial relationship with an individual and you're an attorney, you're not supposed to be engaged with that person. That's a classic conflict of interest, right? And I think we actually saw this as a profession recently with what happened with Tom Girardi, right? Tom Girardi was a famous attorney who was misusing client trust funds, and he had a pal who was at the state bar who he had a financial relationship with. He was taking the guy out for dinner all the time. His kids were working for him. Very clear conflict of interest. And we all know what sort of happened there. I mean, it was really problematic for the state bar, and they got a lot of egg on their face. That they had this investigator that basically was giving Mr. Girardi a pass for all these years. Well, prosecutors, I think, are largely perceived, at least, and I think have largely been tolerant of use of force by police for a long time. And I don't think, I can tell you this. I can't opine on whether it's a direct result of the money, but I can certainly tell you that it definitely undermines trust in the community as to the objectivity and legitimacy of investigations by prosecutors into police unions or police officers when they've been taking money from police unions. That's just sort of a problem. I don't know how else to put it.
Okay.
So that's certainly an issue. I think it speaks volumes, I think, for candidates that take that money in terms of that it's like, would you take fossil fuel money, right? It's another special interest group, and we have to just be clear about, just like we would with any other type of interest, what the money speaks for.
Okay, we're at 4 o'clock, so we're really at a point where each one of you can say some closing remarks, because we have a couple other things to do here in terms of club business. So why don't we start with you, Judge Long, and we'll do a closing remarks.
Okay, thank you, Anne. Again, I guess I would just go back to the expression in terms of my view and my hope that we get another chance to address the issue of cash bail. Our current justice system, I still think, and I'm convinced we haven't entirely dealt with this problem, does a lot more to protect your money than it does to protect your freedom. And that's problematic. And hopefully we will look at things, evaluate where we are, benchmark ourselves to other societies, and ask ourselves, what kind of a society do we want to be in terms of delivering criminal justice? Do we want to look more like totalitarian states, which is what a lot of our statistics look like? Or do we want to look more like our other fellow democratic states, assuming we are small d democratic still? Do we want to look more like the countries in Western Europe and Northern Europe and elsewhere throughout the world that have a more democratic approach to the criminal justice system?
Max, you want to go next?
Sure. Completely agree with the judge. Money is not a proxy for risk, right? As it pertains to bail, how much money you have, there's no consequence on how much of a threat or danger you pose to society. I would also just say generally that reform is safer, right? Things like bail reform, misdemeanor reform, reform as it pertains to the prosecution of kids and enhancements, all of these things that are really becoming a more common thread in these discussions around our criminal justice system and mass incarceration. It's not because these changes and these reforms are going to suddenly result in a huge amount of new crime, and that is or to the contrary. What the data suggests is that these reforms will actually make our community safer, make our criminal justice system more equitable. These are complex issues, and the implications of these policies is certainly myriad. Right? And so I would just encourage everyone to be skeptical, particularly of TV news, right? We love to see sort of the headline about some recent case, but what you don't see for that one awful case where something terrible happened is the hundreds, if not thousands, of other cases where the implications of these policies actually produced a better long-term result. And we really need to start thinking about that. A lot of these policies were put into place to respond to individual cases, which really shocked the conscience. Everything from Charles Manson and the lot, life without parole, and even the return of the death penalty in California, both sort of have a tie-in to what happened with Charles Manson. They were reactive and reactionary, and it's time for our criminal justice system to be thoughtful and actually think through the implications of the policies and make decisions based on data and science, as opposed to headlines, reaction, and frankly racist perceptions around what is causing crime and who is causing it. So I'll leave you with that.
Okay, Paul.
Just in closing, I just want to go back to the point that I made in regards to our criminal justice system. I think when we talk about our community, when we talk about the people that are affected, we're focusing on some of the policies that the DA is putting into, and people are complaining about it. But I think ultimately, we need to step back and think about the communities that we're serving. So like I was saying, I think we need to focus not only on the individuals in the system now, but how we get them out, how we make sure they have the resources to not come back and be recidivists, but also put resources to people and the children, the kids that are about to, or maybe in limbo of entering into the criminal justice system. And I think this approach has to be multi-pronged, multi-agency, to make sure we focus on the people that are affected the most and we don't forget about them. And I think in the grand scheme of things, and when we debate these issues, we forget about the people that these programs, these things affect. And one of the most important things I think we need to do is make sure we have a good relationship up and down the board, from the county supervisors to the DA, to the sheriff, to LAPD, to any law enforcement organization, so that everybody has the input to solve the problems that we currently have, so that we can actually go forward. I think we need to elevate that conversation and go forward in the future. And I think these steps speak to our values, speak to democratic values, and to people that we actually serve in our community. So hopefully, by having these conversations at these Dem clubs, we can really, really plant the seed in everybody's heads that this is not just one organization that's going to make a change, that everybody needs to be on board, from everywhere from the Department of Mental Health all the way up to the prisons, be at one table and say, hey, this is a problem that we have. We need to put a solution towards it. So hopefully with that, we can get somewhere bright in the near future.
Thank all of you for coming. I do want to agree with everything that was said here at the end in terms of this is very complex. And some of the things that you were talking about, where people are putting the fear in us in terms of crimes so that they can incarcerate more, or they're not doing what you were talking about, Paul, where they're not, the question was how many convictions do you have, but they are campaigning on I will convict. There's the DA running, it was in today's paper, who's running in Orange County and saying he's not going to be Los Angeles County, he's not going to be a Gascon, and I'm going to convict, I'm going to do the most I can. And so whether you're running on the number of convictions or that you will convict, I do think we have to get past that, and that it is a complex situation, and we do have to stop the recidivism and go to the core. So you talk about funding, and I think people who talk about funding, defunding, they're really talking about funding things that can help the police or other mental health agencies that can help the police to so it doesn't get to where there is a shooting or something can go worse. So that's really what they're talking about, is when you have funding, what do you fund? So this is a question that we've been talking about over the years, and we will continue. And as these candidates are running and we know how many judgeships there are, we'll obviously revisit this. But thank you all for coming, and we're going to move on to a couple other items